This is Laws 19038, Planning and Environment Law. This is John Milburn. It's week number 3. We're talking about the executive branch of the legal system. Previously, we talked about the role of the Parliament, the role of the judiciary. They're at opposite ends of the spectrum, and we talked about the way in which both Parliament and the courts have a role to play in terms of making the law. The executive sits somewhere in between and straddles the two. And essentially the executive or the administrative branch of the law deals with everything which is not Parliament or not the judiciary. But there are some elements where there are crossovers in both instances. So firstly, constitutionally, there is the division of powers between the three branches. So I'd urge you to have a look at the Constitution in that regard. And when you're doing that, you'll come across Section 61, and that provides that the ministers who are elected ministers in the House of Representatives are actually the ones that will then become head of the executive branch for their respective areas. So those of you that may have some association with the public service may be aware of that concept of a ministerial directive or a ministerial question, which strikes fears into to the hearts of senior public servants, I guess. And that's where the minister, in his or her role as head of the executive branch, is involved directly in some process. So there are some crossovers in that members of Parliament are also potentially members, indeed head of the executive. But generally speaking, those people that are those people that are appointed to the executive have greater tenure than those who are elected into Parliament. Obviously, parliamentarians are subject to elections and may be removed at the whim, if you like, of the voters. But those members, particularly senior members of the executive, are normally appointed either by way of employment contract or a fixed term agreement. So there's a greater degree of security, if you like, job security for them. Not as much as for judges, of course, who have a greater degree of tenure even beyond that. So when I say that there's some crossover, firstly, there's crossover with Parliament in the sense that through delegated legislation, the executive branch have the power to make some laws which will fill in the gaps which are intended to be filled in by Parliament, who creates the overriding structure. So it may be that rules and regulations are actually prepared and implemented and made by members of the executive, and they become part of our legislation, albeit in a delegated form. At the other end of the spectrum, we're used, of course, to the judiciary making decisions in relation to matters. So the executive does have considerable power to make decisions at an administrative or executive level. And we've seen an instance of that in the Predejohn case, which is the first of the assignment questions, where a decision was made subject to conditions that were not satisfactory, and the developer in that case made an application for consideration by the courts. So what we've seen is that if people are unhappy with legislation, the remedy is to change the government and seek to have that legislation changed by a subsequent Parliament. And that can be done. The only law that Parliament can't take away of its own volition is the Constitution. So special rules apply to that. Other than that, one government, if you like, can overrule, or one Parliament can overrule laws that were previously made by a previous Parliament. At an executive level, what we've discussed is that individuals or affected individuals or collectives have the right to proceed to court if they're not happy with that decision which was made at an executive level. And those people have the right to proceed to court. For example, if in the context of planning and environment law, if there is a decision made in relation to an impact assessable development application, then the matter can be determined at this third level, that is by the judiciary. All right, so development applications can be dealt with in the courts. We have the first assignment question, which deals with Predejohn, and the task is to provide some commentary in relation to it. So I will talk about the second assignment question shortly. But firstly, the first one, Predajon. Perhaps the best way to explain a way that you might think about this case is to describe a process which lawyers use often when writing academic legal material, or when writing assignments, or perhaps for those who write judgments when writing a judgment. And we use an acronym. In fact, there's a few acronyms. But one of the most common ones is what we call the IRAC method, IRAC. And the acronym stands for Issues, Rules, Application, and Conclusion. Now, the reason I'm saying this is that you might like to keep this in mind when you're writing your legal assignment work, because it's the logical way that lawyers go about coming to an ultimate conclusion. So what does that mean? Firstly, issues, I. When reading material, let's say a problem that needs to be solved, or perhaps even a case that needs to be critiqued, the reader should be mindful of determining what are the legal issues relevant to this particular case. So the case might be in relation to contract law, and the issue may be whether a purported revocation of an acceptance is binding on the other party. That might be the legal issue. So the important thing is that when you're reading the case, you identify the legal issue or a number of legal issues, which then are discussed further. So once you've identified what is the appropriate legal issue, you might then think about the rules and recite the rules, in other words, recite the law relevant to that particular area of practice. So it may be that after you've identified this is a case about revocation of an acceptance, you might then say the law relating to revocation is this, and the law is found either in this statute or by reference to this case or these series of cases, and then cite them. So you're identifying the legal issue or issues, then you're stating this is what the law says, and here's where the law is found. That's the rule. And then we go on to the third stage, which is application. And in that stage, what we're really trying to do is tie the two together. So we're saying that in relation to the facts of this particular case, the rules will be applied this way or that way. And once we've gone through that process of the application of the rules to the issues in the case, we come up with a final conclusion. And the conclusion might be, therefore, applying the rules as they are at law to the issue in this case, the ultimate conclusion is that the revocation is ineffective and the plaintiff must proceed with the contract, or whatever it might be. Now, as I mentioned earlier, one of the good things about law is that it's not necessarily going to be the case that you must get the conclusion right. You may come to a conclusion which I disagree with, but that doesn't mean that you're necessarily wrong. It just means that I have a different view. So I'm more interested in your ability to identify the key issues, talk about the rules, talk about how those rules are applied, and then maybe come to your conclusion is in many ways is the least important aspect. There are some variations. There's different acronyms. One that I particularly like is MIRAC, where essentially it's the same thing, but we add an M to the front, and the M stands for material facts. So before you start to talk about the legal issues, you may choose to talk about the material facts. Let's go back to Predajon. So in Predajon, we may say, this case relates to an application made by a developer to the council. The council considered the application, imposed conditions. Those conditions were not satisfactory to the developer, and the developer chose to go to the Planning and Environment Court to seek a review of that decision. So you might say that's a very brief outline of the material facts in the Predajon case. But you may go further than that, and you may say that there are other aspects that are important to bring in. When it comes to legal writing, just be a little bit careful not to be too clinical and straight down the line. Particularly at the start of your paper, I would urge you to add just a little bit of colour, a little bit of flavour, so you draw the reader in. You know, people that read legal material are just like everybody else. They like a good story. They like to be drawn in. If you look in my sample document, you'll see that I've drawn extracts from the way in which Lord Denning introduced a couple of his cases, and it's just wonderful. Use short sentences, particularly at the start, get the reader in, and then you can expand from there. So in your critique of Predajon, you might like to talk about how beautiful this particular part of the world is that was the subject of the proceedings, something along those lines. All right, so that's one way that you can think about your legal writing. It's all to do with the way in which you have a thought process and the way in which you record that in writing. Now, that can apply if you're given a question, which is, look, here are the facts of this problem, please discuss and solve. Or it might be a way of considering answering the question in the assignment, even though I've broken it into 4 different subsections. Keep in mind that technique. It might just help you. And it might even help you understand the logic that His Honour took in coming to his ultimate conclusion. Because most legal writers think along the way that I've just described now with that IRAC method. All right, so that's Predajon. Now, the second part of the question deals with issues to do with the Sustainable Planning Act and deals with IDAS. So I'm just going to talk a little bit about that, ecological sustainability, IDAS, the strategic planning instruments, etc. Now, if there are any questions as we proceed, please feel free to interrupt me. All right, ecological sustainability, that's a concept which is relatively new. In fact, the whole area of practice is really quite new. That's what makes it really quite exciting. But if we go back to what was called the Brundtland Report, which was the World Commission on Environmental Development, it was from 1987. It was during that convention, that report rather, that the term the term sustainable development was coined in that particular report. Now, that term has become more widespread, and it's in fact considered in more detail in the lead piece of legislation at a Commonwealth level, which, as you'll recall, is the Environment Protection and Biodiversity Conservation Act of 1999. So if you haven't read the Environment Protection and Biodiversity Conservation Act, I'd urge you to do so. EPBCA is something which you need to become familiar with. So there are some comments that relate to environmentally sustainable development, and that's referred to in the Federal Act. I know the assessment question in the assignment refers to the Sustainable Planning Act, but you've really got to consider that from a constitutional point of view, both the state and the Commonwealth have power to make laws in relation to the environment. So there's only a very limited number of things which are vested entirely, exclusively in the Commonwealth. Many other things are vested in both jurisdictions. So what are some of the key concepts which are important when we're talking about environmentally sustainable development, or ecologically sustainable development rather? And they are things like integrated decision planning or making, and that's IDAS in the Sustainable Planning Act, which is the Integrated Development Assessment System, IDAS. Other things that are important from the concept of ecological sustainability are the concept of conservation of biological diversity, intergenerational equity, and the precautionary principle. So intergenerational equity is really considering that question of, are we now making decisions that appropriately deal with the future generations' needs? So that's intergenerational equity. Is it fair to one generation compared to the other? Another is the precautionary principle. That's one aspect of, if you like, ecological sustainability. And the precautionary principle is really an international concept, and it's becoming more important and more widespread and embraced. Just by way of quick history, the Sustainable Planning Act was introduced in 2009, but it came about in repealing, or it came about following various discussions in 2006 as to reforms that should be considered. And it was as a result of that that the former piece of legislation, the Integrated Planning Act, was repealed. And the Integrating Planning Act of itself was really quite revolutionary in that it introduced some principles which are important now. So, for example, prior to the introduction of the Integrated Planning Act, the way in which councils made the decision was really quite prescriptive, and we used to have zone-based planning, and that has been now replaced with a concept of performance-based planning, which is where there's, if you like, an articulation of the performance outcomes that are sought, but provides a great deal of flexibility on how we get there. So it's far less prescriptive than it was previously. And this is all part of, if you like, ecological sustainability. So that's one part. It was introduced in the Integrated Planning Act, but continued through in the Sustainable Planning Act. Another thing that you need to consider in the context of ecological sustainability is, and is referred to in a separate question in your assignment, is the Integrated Development Assessment System, IDAS, and that is the process for dealing with and deciding development applications. All right. I'll also just mention that there were some discussions through the period of time that led to the Sustainable Planning Act, and there were some criticisms of the old Act. One thing which was introduced in the Sustainable Planning Act was a very clear a very clear indication of how the planning instruments are to work in hierarchy. It wasn't previously very clear. So what we have now is regional planning regulatory instruments are at the top, followed by regional plans, then below that state planning policies, and then local planning schemes. So you'll see a reference to these things, particularly in the Predejohn case, where there are different categories of decisions, or a hierarchy, if you like, of planning instruments. So the ones at the higher level provide a more general, broad overview, and when we get down to the local planning schemes, we're dealing with much more detail. All right, so the Sustainable Planning Act extends the scope of those planning schemes and provides some degree of streamlining and integration through that particular process. All right, so ecological sustainability, have a look at Section 3 of the Act, Sustainable Planning Act, and you'll see the purposes for ecological sustainability, managing the process. Now that's IDAS, so that's why I'm talking about IDAS in the context of ecological sustainability, because part of that is to manage the process, manage the effects of development, so we've seen that in Predejohn case, and continuation and integration of planning at that local, regional and state level. And that's why I mentioned the hierarchy. So part of this overall concept of ecological sustainability is to ensure that the overall framework is fairly clearly set out and still provides a great degree of flexibility, but provides that overall framework. I mentioned that there are a few principles that apply for ecological sustainability. One of them is the precautionary principle. You'll see that a lot in the commentary throughout the textbook and is reference to it. So the precautionary principle, in essence, provides that full scientific certainty should not be used as a reason for postponing a measure to prevent degradation of the environment, and that's Section 5 of the Act. So, in other words, just because it's not 100% certain from a scientific perspective that something is or is not the case, that should not be a reason to delay or consider that as a factor in decision making. All right, so Section 4 of the Act deals with the requirement for decision makers to exercise powers in a way that advances or has regard to the purposes of the Act. So you'll need to look at that as well. All right, so there are a number of cases that deal with the issue of ecological sustainability, and so that hopefully has given you some idea of how to attack question 1 of question 2.1. I've also talked about some of the strategic and statutory planning instruments, which might give you a head start in relation to question 2 of question 2.2. All right, I've also talked about IDAS, so that'll help you with question 4, and to some degree I've made reference to impact assessable development, and just have a look at that, and by all means consider when a matter is subject to assessable development criteria, and what are the ramifications in terms of seeking redress if you're not happy with a decision. All right, now I'm very conscious I've been doing a lot of talking. I'm not sure if there are any questions coming through live. Next week we'll be talking further about the subjects. For the reading for this week was was chapter number 2. So I do urge you to keep up to date with your reading. Make sure that you're following the Zoom sessions. Each week I'll provide my critique, if you like, my summary of various chapters of Bates' book, and you don't have to accept what I say is the most important part of those chapters or my commentaries. You may have your own views on that. You may choose to perhaps view my session or listen to my session in conjunction with doing the reading. So next week we'll be talking about the nature of planning and environment law, and the prescribed reading is chapters 4 and 6 in Bates. So thank you very much for joining me this evening. Please, any questions or discussions through UCrew. I'm getting a few questions coming to me directly by email, and that's fine, but I'd prefer they went through UCrew so that we could generate some discussion amongst students, and also I'm not seen as providing information to one student to the exclusion of others. Right, all the very best.